Marco Gonzalez, and he'll be followed by Dave Graber, Jeff Miller, Rachel Graves with one-time donation, and then Karen Caden.
Marco Gonzalez on behalf of the owners of the property and developer Western National Group. First off, this is an extremely dangerous due process violation to schedule something which technically isn't really even a hearing, and to not even take the step of giving the affected party notice. What are we talking about? How can you take away the rights from someone who spent tens of millions of dollars without even giving them formal notice that you're trying to do so? Strike number one. I'm going to talk about 5 different things in somewhat detail in my 8.5 minutes. It's unfortunate that the record perhaps wasn't fully known by Councilmember OHara when he brought this matter forward, and certainly I appreciate the use of the TEMU colors for the TEMU analysis under the law that occurred. So I'm going to go in somewhat detail and make very clear that we're not here to cost the city hundreds of thousands of dollars in litigation. So first, the agenda report takes issue with the processing of the project under the SB 35 ministerial provisions. This was part of the citizens' lawyers' arguments at the time that they challenged it in the original entitlement. We made clear at that time at the original hearing on appeal, this was never processed under SB 35. The by right processing and CEQA exemption pursuant to the R30 overlay and the housing element, this faulty premise alone renders the conclusions in the agenda report and the demand letter unsupportable. Second, the agenda report claims that Resolution 2022-96, the one that approved the project, substituted a 24-foot standard for the 26-foot standard of Fire Code Section 321.3. This is foundational to Councilmember OHara's and the citizens' demands underneath their letter. However, the city added Section 321.3 to its fire code with Ordinance 2022-12, and it did so on October 26, 2022. Effective January 1st, 2023. This was after project approval. Again, the faulty premise, namely that they were required to make findings under section 104.8 of the fire code, it's actually 104.9, renders the conclusions of the agenda report and the demand letter unsupportable. Both the residents and Councilmember OHara stood up here and said the city council, when they approved this, they inappropriately substituted a new standard. No. That new standard wasn't approved until October of that same year. So the statute of limitations issue. I mean, you have a city attorney. This is, frankly, a no-brainer. As detailed in our letter, the time to challenge the CEQA compliance was within 30 days of the filing of the Notice of Determination of Project Approval. The issue of whether Clark Avenue was a sufficiently wide access road for emergency services was raised by some of these same neighbors and their attorneys, but they did not challenge the project approval, and they cannot do so now. The law simply doesn't give them unlimited bites at the apple. The developer is entitled to certainty once decisions are made. That's how the law is structured. Fourth, the project's regulatory framework was vested through an SB 330 preliminary application that was filed and accepted by the city on February 26th of 2021. The SB 330 process is very important because any changes to the city code that occur after that date don't apply to this project. And as I told you, the city didn't change and adopt the statewide fire code changes until October of 2022, effective January of 2023. Fifth, the AMMR. You know, your fire chief signed an AMMR. So the use of an AMMR to meet fire code standards is endorsed under both the fire code and the California building codes at sections 104.9 and 104.11 respectively. The Encinitas Fire Marshal approved an AMMR for this project, addressing apparatus access on August 15th of 2024. That was submitted September of 2023, and nearly a year later, after reviewing building plans, after multiple discussions with the developer, on August 15th of 2024, that date's important, this included an endorsement on a letter that contained all of the findings required under 104.9 in order to find that there were substitute measures that would not change the standard from 26 to 20, but that would instead provide for the equivalent level of safety as required under law. The approved AMMR required enhanced fire protection and life-saving elements for the project to meet the intent of the fire code, the building code, and to exceed other code requirements, including New exterior standpipes on the east sides of buildings 1 and 4, providing the option to make hose connections near the far side of each building without bringing fire apparatuses onto the fire access roads. 2, automatic sprinkler designs density upgraded by 50% for all the residential units to enhance flow, which improves performance and ability to control fire, increasing likelihood of fire extinguishment. Sprinklers were included in all bathrooms, closets, interiors, and exterior of buildings 1 and 4, regardless of size. 2-hour fire barriers provided between adjacent units instead of 1-hour partitions required by California Building Code Section 708.3, which reduces the potential for burn beyond the unit of origin. These provisions were approved by your fire marshal in August of 2024. Under CEQA law, if somebody wants to challenge, even if we say that that qualifies as a discretionary decision that triggers a potential CEQA review, this is foundational to what this entire situation is premised on, is that this is a discretionary action to make findings under 104.9 that allow a project to go forward without a 26-foot wide street. CEQA says you have, if there's been no process, if there's been no hearing, you have 180 days. You have 180 days, whether you are the city staff, a member of the community, a third party, you have 180 days from August of 2024 to come forward and bring a lawsuit, a writ against the city to require a CEQA document or a new process. We are well beyond the 180-day statute of limitations from the date the AMMR was signed by city staff. Now, like I said, I don't want the city to go down a route where we have to stand up here and talk about all of the Housing Accountability Act penalties that the city could face in the event that it brings litigation, because this would be litigated, to try to take away what has already been given to a developer. In reliance on this, the developer has spent tens of millions of dollars, has innumerable evidence of reliance upon the city's past approvals. These are exactly the principles that vested rights sit upon. The layperson's legal analysis that there was a discretionary action that somehow eviscerates the obligation of either city staff or the public within the statute of limitations to challenge the prior approvals is legal nonsense. Now, I learned the last time I got up here and I said that it's dumb that we're even having this discussion, and the mayor rightfully told me, no, sometimes we need process. And we're not sitting up here and saying that there may be a perfect emergency evacuation situation here. We had this discussion when we talked about approval of this project originally, and we looked at Clark Avenue and the possibility of widening Clark Avenue. But you know what the problem was? And it doesn't get discussed a lot by the residents of Clark Avenue, and that is the city owns a much wider right-of-way. And on the east side of that road, it goes pretty much right up to the edge of their buildings. So if the city wants to enhance the thoroughfare of Clark Avenue, and the city wants to provide additional emergency safety, they're not gonna do it by taking away this project. They're gonna do it by taking away the front yards and an extra 15 feet of these people's property that the city owns. They own that right away. But we collectively, as a city, as the residents on Clark, as the city council majority made the decision that, one, they didn't wanna do it, and based on the opinions of your fire safety staff, you didn't have to do it. So we're not here to relitigate it. This is the third bite at the apple. You'll remember folks got up here when we talked about the approval extensions that were guaranteed by state law, and they wanted to relitigate all the impacts of this project. They're essentially doing the same thing here today. Let's not go down this road. Let's not get sued again. HCD is gonna decertify you. You're gonna end up with builder's remedy. You don't want that. You don't want a lawsuit. Let's do the right thing.